Hello and welcome to another episode of the Contract Warrior podcast. In this episode, we're going to talk about the claims process. We're going to do a quick review, what leads up to a claim, and how to get it done, right? How to get it started. I'm your host, Christopher Williams. I am a former federal contracting officer of 17 years with cradle to grave experience. That includes pre-award and post-award contract execution for construction, services, A&E contracts, and that also includes REAs and claims. If you're interested in knowing more about your contracting officer or how to communicate better with the federal government, check out that free training I put together titled Think Like Your KO. You can head over to thinklikeyourko.com, grab that free training, and it will be absolutely priceless for your workflow. So let's jump into claims and let's do a quick review on a claim. Now, if you haven't listened to the REA podcast, a quick review of the REA process, definitely listen to that. The communication channel in post-award on a contract usually starts out organically with the emails that are courtesy type emails and exchanges that are in lockstep with the contract requirements. When something falls outside of that, then generally there's an RFI provided that flags that item and provides more detail from the contractor to the contracting officer that says, hey, there's an issue, it's outside the contract, and we need a KO's decision on this. Now, just so you know, the government does not submit RFIs to the contractor. No, it's contractor to the government. And so the government will make a response, and then the contractor, if they don't like that response, they can submit a follow-up RFI as well. The point is that an RFI is much different, has a different tone, more facts and details, right? It's a constructive, tactful correspondence. It's solution-based and so forth. It has all the details in there. That is different than a traditional email. Third is going to be an REA. Normally, when the outcome of an RFI is not justifiable or whatever has happened, and it doesn't even have to be an RFI. It can just be a different condition on site, something else. There's so many other ways that a contractor can identify reasons for requesting a formal adjustment for cost incurred due to government-directed changes that it doesn't take an RFI always. But your REA package should be put together based on your prudent ability to demonstrate cost and time controls, which naturally would have email correspondence and then identify RFI elevation, which eventually led to an outcome, which now produced an REA, right? So you'd have a time impact analysis in there. You'd have a nice narrative in there, everything that demonstrates to your KO, hey, here are the scenario plot points. These are the things that happened. We need to get your confirmation on whether or not consideration is allowable, allocable, or reasonable. That's also covered in that REA podcast episode. Now from there, we jump into a claim, right? Which is critical mass. This is like the fourth floor, the major end of the line kind of review, okay? A claim is big league. What that means is now your communication has to be even further finite for lawyer review, right? And so you'll also have a lawyer involved. You can try to do it yourself as a contractor, but it's going to be painstaking. And to some degree, you're going to be required to have a lawyer. Now, the lawyers on the government side are going to interact with you and your lawyer to identify the allowable, allocable, and reasonability of your claim. What traditionally happens is the contracting officer will review your claim. They will use a technical team to evaluate everything that's involved in your claim, just as they would with an REA. The difference is there is a time allotted and lawyers involved to identify and ensure the schedule that correlates with a claim is tracked, right? And good faith between lawyers. And then that will ensure eventually the outcome. The claims process eventually can lead to discovery, which can lead to depositions and eventually a judge making the final decision. So at some point, this claim can break out into a microcosm that requires all emails and all documentations to be elevated to additional parties for review. Now suddenly you have lawyers reviewing all the details of the emails, the RFIs, and any REAs, all the information that's pending in order to come up with their argument and then execute depositions. So they look at the documents, they decide who they want to depose, they depose those individuals and decide if it's worth it to go before the judge to get it reviewed. Now, this is from a KO standpoint. I'm not a lawyer. This is not legal advice. You absolutely need to read your contract in general. This is just for training only. All podcast episodes from the Contract Warrior podcast is all training, right? So this is not direction or not clarity or nothing of that nature. This is training. Verify everything. Now, this can take up to a year or up to 5 years and so on, depending on complexity, depending on discovery, depending on all the things that take time to digest in order to validate your claim and to see if there's merit. Whereas an REA can take anywhere from 30 days to also a year, or maybe even 2 years, again, depending on complexity and all the details associated. But regardless of the workflow, communication should continue so that everybody on both sides has an expectation of how the issue is being resolved, right? But that right there is telling the government, hey, this is serious. As a federal contractor, I'm willing to draw a line in the sand and take this to court. I'm willing to have lawyers review this. I'm willing to dissect it. I'm willing to go through discovery. I'm willing to just go through into the weeds and to get everything out on the table and get it validated. Now, I've seen these claims go both ways, right? Where it looked like there might be merit, but then come to find out there isn't any merit, and it was all for nothing. I've seen this where very little came out of it, okay? Then I've seen cases where a lot came out of it, all depending on the argument and the facts that occurred. Did the government harm the contractor? Did the contractor harm the government? It's those same arguments that continue on. So if you go 0 to 60, where you just file a claim out of the blue, which nobody does, if you ever did that, it would be considered so egregious. I don't think it would be warranted. I've never seen that, but I just know that that is an option. Nothing would stop you, but just know that it would fall flat more than likely, and depending on the reason why you did it. But anyway, I don't know of any lawyer, because first the lawyers will talk and decide if this is even worth it and if it can be digested before it goes before a judge. So just be cautious and go through the workflow. The prudent contractor utilizes emails, RFIs, and even REAs before they get to the claim level, giving their opposing party an opportunity to take a bite at the apple before it elevates. It's not a gentleman's way. That is a natural way. That's a prudent way, because it's showing that you've applied the necessary protocol to try to get this mitigated along the various workflows. You're filing a claim to get results. Just know that doing this, there's some things to get in alignment before you do it, and it behooves you. And here's the point. Okay, so Defense Contract Shield actually helps contractors with claims and helps contractors with REAs. And what happens is, when I review those items, I'm going to tell you if your claim is terrible or if your REA is terrible. I'm going to tell you if this dog has too many fleas. In my opinion, here's what I think you should do. But you may ask me to get it organized for you, which I can do that. But I'm also going to tell you the truth. I'm going to say, okay, yeah, thanks for paying me to organize it, and here's what I think. I think you messed up the government, and I think you're not going to go anywhere. But good luck, you can give it a try. Or I'm going to tell you, hey, actually, yeah, what the government did was tyrannical. They took a strong approach. They didn't allow you to communicate. They didn't address anything. They came through authoritative, and they directed all these changes, and you didn't have a chance to, communicate. You didn't have a chance to negotiate. You were just strong-armed into different decisions and different scenarios. And the outcome was you taking on extended overhead and losing a lot of time, and so on and so forth. There could be a blowout on your side with logistics in terms of relationships with subcontractors and all the other details that will never be recoverable. How do you articulate that before the government in a prudent manner? This is what Defense Contract Shield does, and helps support contractors in doing so. But if you come to me with a claim that's like $30,000, I'm not taking that. I'm not helping you with that. And if your claim is terrible and stupid, I'm just being honest. If it's stupid and dumb and you're just a contractor looking for money, I'm not helping you with that either. And I'll know, because I've worked claims and REAs. I will know if you're just fishing. If you're fishing the government for REAs, if you're fishing the government for claims, Defense Contract Shield is not the organization to support that. So we support contractors who are in situations where they have been treated incorrectly, not badly, incorrectly. Badly is opinionated. Incorrectly is protocol not applied. So if the government has taken extra measures to force the contractor to do certain things, then yes, that is a problem. But if you think you should have been paid more on a certain project, and in fact, you just didn't have a good proposal, that's not the government's problem. So with that said, a quick review can address that, and I can tell you exactly where you're on the wrong path and you might want to recalibrate or rethink your process. Or this is good to go. This is exactly what needs to happen if you want me to review it and help you dial it in. Because the key here is not gouging the government. The key here is getting the contractor right side up, right? The government's not going to get right side up. They're already right side up. Is the contractor going to get right side up? Because they might be upside down simply because it's a large project with a lot of challenges and the contractor got drowned out. Maybe they're a subcontractor who didn't get a voice. Whatever the case is, there's so many scenarios out there. So most clients get a hold of us at the REA level. And I can tell during the REA if, in fact, it's a claim level eventually going to go to claim. I can see if your REA is going to be agreed to or not. What are the chances, right? Or if you need to prepare for claim. And that's a service that Defense Contract Shield provides, right? So the Contract Warrior podcast is for training, along with Defense Contract Coach and the Think Like Your KO training. And then there's a course with it and everything that's available. But Defense Contract Shield does hands-on review and analysis to try to identify whether or not the contractor has merit or not. Defense Contract Shield does not address the government on behalf of a contractor. Absolutely not. The cost is not cheap, but the value is priceless because you do not want to get this wrong. You do not want to end up in a claim where you're under discovery and suddenly you cannot represent yourself before the government properly. Your lawyer doesn't know how to communicate contracting, just knows the law, and so your lawyer's drawing straws and trying to figure out what do the terms mean when it comes to federal contracting. When I was a contracting officer, I had been deposed and I have had conversations with lawyers in deposition, and they were clueless about terminology that I had to clarify for them. They thought it was contempt with me speaking. No, I had to stop them after answering their question genuinely and saying, no, that's not the case, or no, and then saying, hey, absolutely, I need to add something here because I think you're using terminology incorrectly. So there is a gap between the KO and the legal beagles. And with that gap, that's where Defense Contract Shield comes in. We fill the gap. We advise what you think you should do. You can decide if you want to go left. If we advise you should go right, that's definitely your call. Anyway, with that said, if you have that type of challenge, and absolutely, the point is to avoid a claim. The point is to exercise REAs and get things resolved. A lot of cases, that's not the case. A lot of cases, an REA is just the precursor to the claim. With that said, if you don't get your ducks in a row in an REA world, it's going to be a dog show in the claim world, or a dog and cat show where there's just a lot of arguing and a lot of scrapping, because the reality is you need to set up stage before claim. And then it makes it easier for the government to go ahead and digest your claim. It makes it easier for the lawyers to go ahead and have conversations. It's easier for deposition. It's easier for everybody. So hopefully this particular episode of the Contract Warrior podcast has been informative and maybe eye-opening for some, maybe just the same for others, but insightful nonetheless based on a former KO and their experience with claims and REAs, right? With that said, have a good day, and we'll see you on the next episode.